Hello, my name is Hank Schaefer. I'm a probate attorney with Groth Associates, and I've been asked to address what happens to property when it is left and enters an estate, how you go about selling the property or otherwise transferring it to the heirs. The first step in Ohio is figuring out if the property actually needs to go through probate. Over the past 10 years or so, Ohio legislature has made many changes to the law that have allowed many family homes to escape the probate process. For several years, Ohio used a transfer on death deed that basically allowed the owner of the property to designate where the property would go when they passed. Now Ohio uses a transfer on death affidavit, so you could go down to your local recorder and file an affidavit designating where the property would go without having to redeed the property. There are also survivorship deeds. Those are most often deeds that gone to husband and wife, so basically the property is owned by the husband and the wife for the duration of their lives, and then when one person passes, the property automatically transfers to the other spouse on the deed. If the property is in a trust or is owned by an LLC or other sort of corporation, it also does not need to transfer in probate. If you have such a house where there is a transfer on death provision, instead of going to the probate court, you would fill out a transfer on death affidavit indicating that you are the person who has survived and that you are entitled to the property. You take that and a copy of the death certificate to the local recorder and auditor and record it, and the property will be placed into your name. At that point, if you do not want to keep the property, you are free to sell it just as you would any other piece of property that you own. It is yours entirely, and you can do with it as you wish. If the property doesn't fall into one of those categories, that is, in the decedent's name, without a transfer on death provision, it will need to go through the probate process. At that point, the only person who can sell the property or otherwise dispose of it is the executor of the estate, or the personal representative of the estate. When you begin the probate process, the first step of the process is to have the property appraised for the inventory. So you will have gone to the probate court. Usually at this point you've hired a lawyer because if there's real estate in the estate, it's usually large enough that it requires a lawyer to help navigate the process. And you're going to go to the probate court and they're going to ask you for an inventory of the estate. And the house will be included on that inventory. To get a value for the property, the probate court will have a list of approved people, and you have them appraise the property and put the value down on the inventory. Ohio law also now allows you to use the auditor's valuation that most auditors in most of the counties have on their web pages. You can pull the dollar value off the web page and put it onto the inventory. If you've hired an attorney, the attorney will help you with that step. Once the house is listed on the inventory and is part of the estate, if you wish to sell it, whether or not you can is determined by how the property is passing. If there's a will, and that will gives the executor power to sell the property, the executor may sell the property without the permission of the probate court. The will gives that permission. However, there are some limitations on that power to sell. First of all, the executor must act with what is called a fiduciary duty. They must act in the best interest of the estate and not in their own best interest when selling the property. This means that they could not, say, sell it to a friend at a heavy discount. They have to sell it for a full fair market valuation to the person that is buying it. It also means in most cases that they cannot self-deal, that is, they cannot buy it themselves. There is an exception if the executor is the surviving spouse of the decedent. It just makes sense that mom can buy the house after dad has died. So Ohio law allows for that. But otherwise, self-dealing is rarely permitted under Ohio law. If the will only gives a limited power to sell, you still have the power to sell, but you must follow whatever limitations are listed in the will. If the will says specifically to sell it to a specific person or charity, that is to whom you must sell the property. It cannot be placed on the full market for sale to anyone. So basically, read the will and do what the will says once the house is in probate. If there is no will, then you must obtain permission of the probate court to sell the property. The way this is usually done is the executor finds a buyer, finds a price that they're going to sell it at, and then you go to the probate court and say, probate court, here is who I plan to sell the house to, here is the value that I plan to sell it at, and if the probate court thinks that that is a fair and equitable sale, they will then approve the sale. This may also involve getting the consent of the heirs and the surviving spouse, so it is a fairly elaborate process. In fact, one of the best advantages of having a will is having the power to sell the real estate without consent of the court. But if you don't have that, I suggest that you hire an attorney to go to court. Once the probate court has approved the sale, the probate court will allow you to take an executor deed or give an executor deed that allows the house to be sold. It is important that if the will does not give you the power to sell, when you do go to sell the property, that you advise buyers that there is that limitation, that the probate court will have to approve the sale and make that a contingency in the purchase and sale contract for the house. Once you've sold the property, you then dispose of the proceeds according to the will, or if there is no will, according to the order of the probate court. That usually involves distributing the proceeds to the heirs. Selling real property after the loss of a loved one is an arduous process. Not only are you dealing with the loss of the loved one, you're also dealing with a complex legal process. That is why we recommend that you hire a probate attorney whenever there is real property in the estate. It shouldn't be a difficult process. Thank you.